We're currently in year 3 of the large language model revolution. Like broader society, the legal profession and the courts want to make the most of the changes arising from this fourth industrial revolution, while also seeing AI regulated in a reasonable way, an issue close to my heart that I write about in my book, Man-Made, shameless plug, at all good bookstores. However, I'm but a humble journalist. I'm not a lawyer. This next speaker has extensive experience in family law and corporate governance and is a partner at Marsden's Law Group. In 2019, he was appointed by the Attorney General as a Law Society representative on the board of the Legal Aid Commission of New South Wales. Please put your hands together for President of the Law Society of New South Wales, Brett McGrath.
Thank you very much. Well, good afternoon, everybody, and it's a pleasure to be here, but I understand the apprehension when everyone says, oh, legal's rolled in. So it's usually a response that we get. So I know I'm on the before the lunch agenda item. I want to thank the conference for the generous invitation to come and speak to you all today. And I'm happy to do so because the topic I'm going to explore is one of the presidential priorities for this year for the Law Society of New South Wales, artificial intelligence, and how the legal profession is going to respond, adapt, and also influence our response to AI. At its best, like many areas adjusting to Gen AI, it could make legal work much easier. And free solicitors to focus on solving the harder aspects of legal matters. At its worst, it could create bad decisions that affect hundreds of thousands of people and alter the way legal challenges work. That could also undermine the security of aspects of day-to-day behaviour we currently take for granted. So today I'll look at the implications of generative artificial intelligence for our justice system, and we'll touch on what is likely to mean for practicing solicitors, the courts, regulation, and society as a whole, and our right to access for justice. But before I start, I'd like to take us all on a step back to Sydney in 1986. In October of that year, the Lexpo Symposium showcased the new technology for legal work, and speakers noted that by 1990, solicitors would be redundant if they could not use computers. Now, based on some of the work I've seen 38 years later, I'm not so sure that's the case, although paper files can't be hacked, and that's one bonus. Trevor Haynes, the then Secretary of the Attorney General's Department, delivered the keynote address. He outlined how advances in technology were affecting community expectations of the legal profession, a very similar theme today. As an aside, a prize was given to the crowd on the day. It was a Remington computer with a 640 kilobytes of memory, a 20 megabyte hard disk, and word processing capabilities, valued at the low cost of $14,500 or about $45,000 today. Other speakers said that new technology would affect lawyers in the way they practice in every area of practice. They raised a wide variety of legal and security concerns. They raised issues around evidence, how the courts would function, and what clients would expect of lawyers and their conduct. I assume you can see why I'm starting all the way back there. Society has faced massive upheaval from computing in the recent past. We survived as lawyers as a profession alongside almost all office workers. Less so stenographers and typists, but the rest of us did okay. But for the purposes of today, some of the predictions were spot on, but many of them also were not. So, are there differences with today's technological change and what predictions we should pay attention to? In law, the adage has become that AI won't replace lawyers, but another lawyer using AI will. This might be true of other areas of work as well. It's widely agreed that generative AI does not currently have the capacity to altogether replace lawyers. It's also unlikely that Gen AI could currently manage the roles of legal support staff like paralegals, despite some of the wild claims. One of those claims from Goldman Sachs last year suggested AI could automate 44% of all legal work in the United States. But instead of mass layoffs of lawyers, we're seeing the profession there grow, and it continues to grow here in New South Wales by about 3 or 4%. Nonetheless, last year, ChatGPT passed the US bar exam So within 6 months, it achieved less than 10%. It was an abysmal fail. Within 6 months, though, it achieved over 90%. So we're seeing a rapid change and ChatGPT and AI evolving. Although a subsequent investigation by MIT recently has shown that it did pretty poorly compared to lawyers who passed on their first attempt, especially in the essay writing portion. Also, towards the end of last year, a specialist legal AI scored 74% on the English solicitor's qualifying exam. So we knew all of this was coming, though. It's not unexpected. Back in 2018, the large legal publisher and legal support service provider LexisNexis had already outlined 4 areas, or primary areas within the legal field that would play to AI's strengths. So due diligence, prediction technology, legal analytics, and practice management, amongst many. They noted that some of the changes AI would drive included changing cost structures, more cases and commercial deals, and newer ways to practice law. Many of the positive sides of these predictions are already starting to come through. It's providing lawyers with more time to grow their businesses and to do harder, non-digital parts of practicing law, like decision-making, critical thinking, and legal analysis, alongside with the very human interaction with clients. In April, the Australian Financial Review covered a months-long trial with generative AI intelligence and everyday legal tasks at the global firm Ashurst. On average, its lawyers used AI to produce client briefings 2.5 hours faster. In June, Tech Times reported similar findings from a UK firm, Silver Circle. Their trial found that lawyers were roughly 2.5 hours quicker with brief writing, half the time it would have taken them to write it independently. And in May, The Australian reported that PwC is showing lawyers can earn up to 49% more if they are harnessing emerging technology. So while the data is based on the US market and possibly slightly inflated, it's not outlandish, though, to suggest that Australian jobs look likely to follow the same trend. And with AI and automation becoming more readily available, AI is disrupting the legal sector, and the opportunity for law is huge. By allowing different ways of potentially ensuring cost structures, it may allow for better fee transparency for clients as well, and more fixed rates in certain areas of legal work. These clients include not just those in the private sector, but the Australian taxpayer through the Australian government clients. The need for a lawyer to oversee this work will not disappear. Conversely, it could allow more capacity to serve more clients as well when you have those productivity gains. And it could have the positive knock-on effect for many clients alongside their financial ability to access justice. On the macroeconomic front, in an era of persistent inflation, the productivity gains from the use of AI in the legal sector, including courts and tribunals, should spur all governments to encourage and facilitate investment in this area and lead the change. But are there some downsides? Gen AI is very good at processing data, but it is weaker in areas requiring emotional intelligence and human judgment. The Chief Justice of New South Wales, the Honourable Andrew Bell, has recently written that, and I quote, and it's up there on the screen, "The combination of cost, efficiency, and laziness may generate disproportionate or even overwhelming reliance on generative AI, the judicial and wider legal system, in a way that not only exposes it to abuse, but more fundamentally has the capacity to alter the high regard in which judges and their judgments are currently generally held by the broader community, to the extent that their decisions may be viewed as little more than another output or result of generative AI." The Chief Justice has gone on to note the phenomenon of truth decay, which has grown from things like the well-documented fact that AI is prone to generating incorrect or false information, which we term hallucinations. As we know, the justification for generative AI's outputs can never really be bound to truth. One can't check ChatGPT's sources, for example, the black box problem, because the source is statistical fact, and most of the time the set of words tend to follow another. So, what, you may say? No lawyer would solely rely on AI when representing a client, so where is the threat? Well, to that point of laziness that the Chief Justice mentioned. Last year, we saw the infamous case of Mata and Avianca Incorporated, where lawyers in New York used ChatGPT and it went very wrong for them. Submissions were filed, which included non-existent judicial opinions with fake quotes and citations, all thanks to ChatGPT. The judge characterised ChatGPT's legal analysis as, and I quote, gibberish. Ultimately, the judge found that the two lawyers who were primarily involved breached the federal rules of civil procedure and, amongst other things, were ordered to pay a fine of about $5,000. They were also enormously embarrassed on the global stage. The Canadian case of Zen and Chen from earlier this year unfortunately followed a similar set of AI-related issues. Their lawyers inserted two fictitious cases into a notice of motion, which were entirely invented by ChatGPT. So the Law Society, we are a co-regulator of solicitors in New South Wales, which means we license solicitors and we also discipline solicitors. Thankfully, I can say that we've not yet had such cases here, although it's of course possible, but nearly at every event I remind solicitors of their ethical obligations and of these instances overseas. And while these cases are a serious breach of their respective ethical and professional requirements, both also demonstrate something positive. The rules of procedure with which lawyers must comply are an important safeguard and are holding up in most instances. And equivalent safeguards exist here. So many pleadings in the Supreme and District Court of New South Wales, for example, must be verified by an affidavit. Similarly, in the Federal Court of Australia, pleadings must be accompanied by a certificate signed by the lawyer that any factual and legal material available to the lawyer provides a proper basis for each allegation, denial, and non-admission in their pleadings. In November 2023, guidelines were also issued to solicitors by the Law Society of New South Wales. They outline how AI may be used in a manner consistent with a lawyer's ethical and professional obligations. The Law Society has also set up its own AI task force, includes judges, lawyers, academics, and legal technology experts to guide the approach of solicitors and the courts using AI in New South Wales. And last year, the New South Wales Bar Association also released guidance for barristers considering the use of AI language models, including ChatGPT, in their practices. Our view is that legal practitioners should neither avoid generative AI completely, nor totally and unquestioningly embrace it. First, without understanding its limitations and giving critical thought to maintaining their professional obligations while using it. Further, the New Zealand and UK judiciaries and the Australasian Institute of Judicial Administration have produced guidelines on AI use in courts and the steps that judicial officers may take to ensure that AI is not misused in the Australian judicial system. The Supreme Court of Victoria has recently released guidelines for the responsible use of AI by all litigants, including self-represented litigants. And the Queensland courts have released guidelines for responsible use of generative AI as well. It seems fair to say then that the majority of the legal profession and judiciary are alive to the reality and dangers of the use of AI in the justice system. Checks and balances within the courts and also professional regulators such as the Law Society of New South Wales are likely to keep the worst effects of misusing AI in law to a minimum. So, are we in need of more regulation and more law then? Well, there are around 42,000 solicitors in New South Wales and 2,500 barristers and hundreds of judges. So while they help bolster the administration of the rule of law and stand against AI eroding or potentially eroding the justice system, few of the 8.1 million people in this state are covered by the regulations and professional obligations of the legal profession. So let's consider the wider perspective. The Human Technology Institute at the University of Technology in Sydney launched a report last year in May called The State of AI Governance in Australia. Around its launch, the Institute's Lauren Solomon said, and I quote, "AI systems can cause real harm to people, both to individuals and society more broadly. Threats to safety, discrimination, loss of personal information, and manipulation need to be addressed by organisations using AI systems to ensure our lives are improved by this innovation." AI is developing rapidly, as are attempts by regulators in jurisdictions around the world to grapple with it and address its risks. However, as Ms. Solomon went on to point out, while reform is undoubtedly needed, AI systems are not operating in a regulatory Wild West. AI systems are already subject to privacy, consumer protection, anti-discrimination, negligence, cybersecurity, work health and safety obligations, as well as industry-specific laws. You can see some of the relevant acts on the screen, which are tiny, but it already gives you a taste of what's out there, which AI is already subject to. And across several areas of both federal and state governments, we are seeing Australia's first steps towards defining its own approach to regulating AI. In March, I had the privilege to appear before the Upper House Committee examining artificial intelligence in New South Wales. There I urged the New South Wales Government to build upon and adapt existing approaches to AI that are emerging both in Australian and international jurisdictions. As I then noted, we need consistency with other areas of domestic law, such as administrative, privacy, cybersecurity, consumer rights, and human rights law. And in July, the Legislative Council responded to the submissions it heard and handed down its report from the inquiry. And in that report, it made 12 recommendations. Hopefully you can see those terribly overpacked slides that I've got up there. That's the lawyer in me is putting those up there for completeness. I considered editing them, but thought you might want to get a sense of the tedious masses of writing that lawyers have to deal with on a day-to-day basis. But it's pretty clear, and I'm happy to say that one of the 12 recommendations of that report was the recommendation for the New South Wales Government ministers to liaise with their state and federal counterparts to ensure a consistent approach in the governance of artificial intelligence. This came at recommendation 7. Gladly, it was followed with recommendation 8, which suggests that the government conduct a regulatory gap analysis as soon as possible in consultation with relevant industry, technical and legal experts too. Primarily to assess the relevance and application of existing law to artificial intelligence, identify where changes to existing legislation may be required, and determine where new laws are needed. The report is about 100 pages long and worth reading, as it provides a good snapshot of where our Parliament is at in considering the threats and opportunities associated with AI and what might be coming with legal change. In addition to the many positives of AI, the report also outlined 6 top risks that AI poses at an immediate practical level. They are what you might expect and may have heard before: AI's impact on work, privacy and cybersecurity threats, data bias giving rise to bias in AI, the hallucination issue, accountability and transparency, and the effect of generative AI on copyright laws in the industries that will be drastically affected by that. The report also notes some particular areas of concern within these issues, which I'll return to. But in terms of privacy and cybersecurity threats, one of the more noteworthy threats facing many individuals, businesses and governments are like those what we saw in February this year in Hong Kong. There, a finance worker at a multinational firm was tricked into paying out 38 million Australian dollars worth to fraudsters using deepfake technology. The fraudsters posed as the company's chief financial officer in a video conference call. The CFO was alongside what the employee thought were several other members of staff, all using deepfake video and voice technology. They looked and sounded like the colleagues the employee knew and recognised, but all of them were in fact deepfakes. The case is one of several recent episodes in which fraudsters are believed to have used deepfake technology to modify publicly available footage to cheat people out of money. You may have heard of the mum and dad scams occurring using voices in Canada and those other places. At the press briefing in February, Hong Kong police said that they made 6 arrests in connection with similar such scams, but they did not reveal the name or details of the company involved in the $38 million scam. Thankfully, legislation exists here to combat fraud and covers actions such as this in theory. Of course, stopping crime is another issue. Nevertheless, a fragmentary approach of AI law and policy in Australia represents a fundamental challenge for the New South Wales Government and its inquiry into AI. It is a challenge both in evaluating the current state of the law and in developing policy initiatives to promote safe and responsible use of AI in New South Wales. Key law reform initiatives at the Commonwealth level will also have a significant impact on AI regulation here in New South Wales. These include the review of the Privacy Act from 1988 and the 2023 to 2030 Australian Cyber Security Strategy and the Safe and Responsible AI consultation by the Commonwealth Department of Industry, Science and Resources. This illustrates that from a legal point of view, we must make sure that we adopt a consistent approach to dealing with the use of AI in our constellation of Australian legal jurisdictions. So far, I think the picture has been reasonably optimistic. So I want to move then from broader issues to what I think is specifically challenging with AI and regulation and society in New South Wales right now. So the Law Society has shown its support for the state government's AI strategy, assurance framework, and mandatory ethical principles for AI use. This is very important as it addresses implementing AI in government in an ethical way. I think it's our biggest legal concern in relation to AI in New South Wales and Australia. While everything I've mentioned so far, of course, requires serious consideration, no clearer example is before our MPs of the need for secure, ethical use of AI than the recommendations of the Royal Commission into the Robodebt scheme. Sadly, the failure of the Robodebt scheme presents a counter to the idea of successful AI regulation. Robodebt wasn't at the far end of the spectrum of what's possible with AI. It wasn't Skynet coming down and determining things and challenging humans' existence. And it wasn't deepfake technology causing widespread fraud, and it wasn't a cybersecurity breach aided and abetted by AI. It was simple, real, and large scale, the largest example of automated decision-making gone wrong in Australian history. And the damages were in the billions, and it affected close to 500,000 people. Robodebt destabilised administrative processes in government and procedures and challenged the principles that underpin them. It did so by reducing administrative discretion, removed human intervention, curtailed transparency and information provision, assuming guilt rather than until proven innocent, and reversing that onus of proof. It also reversed a basic legal principle that in order to claim a debt must be proven to be owed. Indeed, Robodebt algorithmically encoded a fundamental lack of procedural fairness throughout its various procedures. These observations highlight that algorithms do not simply reproduce less or non-automated administration in an equivalent fashion. They can fundamentally recast administrative and legal principles. From a technical legal point of view, the Robodebt automated decision-making process was founded on an abrogation of the government's statutory requirement under the Social Security Act of 1991, specifically sections 1222 subsection A and 1223, amongst others. Income averaging in assessing welfare recipients' annual income for the purposes of raising debts was actually not open to the government to do. This was actively ignored in the creation of the automated process. Legal advice about this appears to have been ignored as the processes took hold and for years afterwards. In short, it was a failure. Its disastrous effects have been so serious that $1.8 billion of settlement was reached between the Commonwealth and the class action plaintiffs back in 2021. And formal recommendations were made last year by the Royal Commission into the scheme. These included referrals which may lead to civil and criminal prosecution, so we wait to hear what occurs on that count. I'll say at this juncture that I appreciate AI and automated decision-making are overlapping but not entirely synonymous concepts or things. But for the purposes of today's address, I won't go any further than that, but simply to state that I think it's necessary to include both in the context of this discussion, especially as AI looks likely to increasingly overlap with automated decision-making in government. Numerous legal commentators and legal academics have highlighted problems with using AI and automated decision-making in government and issues with privacy law, freedom of information, and judicial review. People such as law professor Anna Huggins, writing in the University of New South Wales Law Journal in 2021, have thoroughly explored the concerning legal dimensions that AI can pose. Others such as Jennifer Cobb and Edward Santo, to name a few, have noted legal issues with challenging AI use in government. And the Australian Law Reform Commission and the Australian Human Rights Commission have called for legislative reform to judicial review and administrative law to better deal with AI and automated decision-making. The report of the Royal Commission into Robodebt made 57 recommendations. I won't put all 57 up. Recommendation 17.1 suggests reform of legislation and implementation of regulation where automated decision-making is implemented. It noted there should be a clear path for those affected by decisions to seek review. Departmental websites should contain information advising that automated decision-making is used and explaining in plain language how the process works. and business rules and algorithms should be made available to enable independent expert scrutiny. Recommendation 17.2 calls for the establishment of a body to monitor and audit automated decision-making, in particular, monitoring technical aspects and their impact in respect of fairness, avoidance of bias, and client usability is also needed. The report into AI use in New South Wales, the one that I mentioned earlier, also contains a recommendation at number 5, that the New South Wales Government consider maintaining a publicly available register of automated decision-making systems available within government and its agencies, and when they are applied. Given the publicity around this issue, it is reasonable to think that policy oversight and legal safeguards in government are changing to meet the legal demands around AI. Indeed, we are seeing many levels of government scrutiny. One might ask then, how likely are we to see serious issues with automated decision-making or more advanced AI in government again? Perhaps somewhat alarmingly, automated decision-making to perform government functions and the use of Gen AI more broadly is prevalent and becoming more prevalent across all portfolios here in New South Wales. In March, the New South Wales Ombudsman publicly uncovered the presence of over 275 automated decision-making tools, raising questions about how the tools are administered and their usage is disclosed. And 275 is a conservative estimate. The data the survey used was voluntary, and only 1/4 of the New South Wales 439 public sector entities, including councils, departments and agencies, participated. Only 1/4. Moreover, a public review of procurement records, government websites and other public information, which supplemented the survey, found an additional 702 potential automated decision-making tools. Perhaps more alarmingly, the report which the Ombudsman commissioned estimated an increase of 50% in the next 3 years of New South Wales departments and agencies' use of automated decision-making tools. In his statement accompanying the release of the report, the New South Wales Ombudsman Paul Miller was clear. He said that the lack of mandatory reporting of automated decision-making tools or a public register had stifled, and I quote, informed debate about what assurance and regulatory frameworks may be appropriate for automated decision-making use now and into the future. Mr. Miller also said the lack of mandatory reporting made it impossible to know whether the systems were, and I quote, legally validated or tested, and whether and how it is subject to ongoing monitoring for issues such as accuracy and bias. He went on to say of particular concern was the fact that there was little evidence of external audit or external legal review or advice, with less than half of the smaller sample that was checked by the Ombudsman having any legal input or oversight. The tools were not just for mindless data processing either. They included such things as providing information about children and child protection, classifying the likelihood of domestic violence recidivism, classifying inmates, and detecting people on watch lists entering hospitals. The Ombudsman's report said that even with a human in the loop, automated decision-making programs still impact people's rights. For example, recommending which communities to allocate less or more resources towards, or how to classify threats in populations. The Ombudsman's scrutiny comes against a backdrop of not just Robodebt at a federal level, but 2 of the state government's own controversial automated decision-making case studies. The first one, Revenue New South Wales, the New South Wales Government's Taxation and Debt Recovery Agency, a favourite of everyone in this room, used an automated decision-making tool between 2016 and 2019, and again between 2019 and 2022, that issued what were found to be illegal and often inaccurate garnishee orders to recover debts. Garnishee order, of course, being an order, a court order that allows you to recover a debt via a third party, such as a person's employer or a bank, and the third party is referred to as the garnishee. Revenue New South Wales automatically raised fines, which were then pursued through these garnishee orders. As the legal opinions behind the Ombudsman's finding made clear, raising fines requires an authorised decision maker to make a decision. That is, a human must reach a mental state of being satisfied in a decision for it to have taken place. This position was upheld by the full federal court in the case of Pintarich and the Deputy Commissioner of Taxation in 2018. The New South Wales Ombudsman found that the automatic process did not have this and was therefore contrary to law, failing to comply with the Fines Act of 1996. The second example is last year the New South Wales Police discontinued its suspect prediction automated decision-making tool that overrepresented Aboriginal and Torres Strait Islander people. That an issue of discrimination at this level was apparent in the police process is a real cause for concern. Thankfully, these processes have been altered or stopped completely, but arguably this could have been avoided. As the New South Wales Ombudsman said in April this year, and I quote, "Obtaining early legal advice is essential for automation projects involving high-volume government decision-making, especially where it may affect a power that is or may be discretionary or requires evaluative judgment. This is particularly the case if the decisions may affect vulnerable people or where the costs or savings associated with such a program may create a disincentive to the agency to scrutinise the legal basis for decisions." It is, to be frank, breathtaking that after Robodebt, a myopic regard for legal advice around AI use in government could be taking place on a large scale within our own state government. And whilst this may seem like somewhat strong language, chipping away at the rule of law within our institutions and our administrative state is deeply concerning. And therefore, I think it's deserving of a serious response and needs much stronger language to bring this to light and hopefully to get government to change course. This throws into sharp relief the ultimate question that I will deal with today: is access to justice a service or a right? I'm sure you know that this is a bit of a false question. It's a right. You do have access to justice. But in the context of what I've covered, AI can, and already potentially has, changed that formulation in several instances, particularly in relation to state use of AI and automated decision-making tools. The Honourable Stephen Reyes, recently retired as a judge of the Federal Court of Australia, noted in 2015 that, and I quote, "A system of justice is an institution for the redress of grievances. It can only command the respect of a society's members if they trust that it is impartial, equal, transparent and principled system that gives effect to the rule of law." The right of access to justice is enshrined in many areas, and the right to access the courts and the right to procedural fairness when affected by the exercise of public power are also common law rights in Australia. What amounts to procedural fairness at law is not necessarily an easy question to answer though, but it generally requires the people directly affected by proposed administrative acts, decisions or proceedings be given adequate notice of what is proposed. This is so that they may be in a position to, firstly, make representations on their own behalf, or secondly, to appear at a hearing or inquiry if one is to be held, and thirdly, effectively to prepare their own case and to answer the case if any they have to meet. In the context of AI and automated decision-making, imposing the burden of proof on a person when they do not have the access to enough information to understand how a decision affecting their interests is reached is procedurally unfair, particularly when you think about the enormous resources and weight of the state against the individual. Victorian Legal Aid have pointed out that understanding how a debt is calculated, whether by AI-informed decision-making processes, or a human being without technological assistance, is essential for a decision-making process to be fair and for it to be seen to be fair. Transparency is fundamental to this process. It is critical as a critical protective function for citizens potentially affected by AI-informed decision-making. If a person cannot be informed of how a decision was reached because the technology involved is essentially that black box, often even to those who understand the coding, engineering and computational logic behind it, then we have some problems. All these issues crystallise around one central point. By its very nature, automation reduces the need for human input. Yet if such input is a criterion for reviewability, a growing range of administrative processes will be beyond judicial scrutiny. As Professor Huggins has noted, these legal gaps limit options for judicial review and executive accountability, which is concerning given automated systems' potential to replicate flawed decision-making processes on an unprecedented scale. We may be entering territory where legal challenges to new versions of things like Robodebt are needed, but increasingly hard to make out through the courts without legal reform. And the final point here is the scale. The New South Wales government has been reported as not just the largest employer in New South Wales, but the largest employer in the country. The decisions of the government can affect all of us at some point, and should AI be an unchallenged part of this? So, in conclusion, The Law Society of New South Wales has taken the public position with the New South Wales Government that we see merit in government acting as a role model and leading by example in the adoption of ethical AI and responsible technology practices. In our view, the public sector should be held to a higher standard of responsible use of AI. Government should be a model user of AI. It needs to assist the creation of appropriate behaviour and standards which can then be applied more broadly in the private sector's use of AI. Citizens should know when and how automated decision-making is being used in a way which significantly affects their rights. AI can produce outputs that are insufficiently robust or unsafe for the reliance humans place on them. Both regulated personal information and other non-identifying information may be used in ways which are unreliable, unsafe, and cause real damage to people. Legitimate expectations to be informed of how and why one is being singled out or differentiated for treatment, if a decision is reasonable, need to be fairly met by governments. And given the potentially broad reach of AI, this underscores the importance of coordination between all jurisdictions on the regulation of AI. And while the appropriateness of and transparency of AI use are broad questions, considered appropriate regulatory safeguards to manage these risks are needed. And whatever approach is adopted by our parliaments, it must ensure that the public service and the government of the day are subject to reasonable uses of AI and automated decision-making, and that the law is enforceable against them when it is, unfortunately, necessary. So, the nearly 450,000 people detrimentally affected by robo-debt illustrates the need for this all too well. And to do otherwise is to risk eroding the very rule of law upon which our society functions. So thank you all for the opportunity to address you all today.
Thank you so much. Welcome. Thank you so much, Brett. I'm going to get you to stick around for
sure.
two very brief questions that we've got online.
Absolutely.
One of them, I love this, it may be somewhat ahead, but how will the law cope with sentient, self-aware, autonomous quantum AI?
Well, that was someone said that AI will get to the point, and I think that's what it refers to, where it will start being able to read your brain waves to be able to pick up what's happening. I mean, that is some very scary frontier stuff that we're facing. And that's why, certainly with the deployment and use of AI, we've set a task that any approach by the government needs to be one that's informed, that's rights-based. So an example that I use is in the United States. They have a Bill of Rights and a constitution that restrains government. That's a lot of what it is. In Australia, we don't. We have parliamentary supremacy. We're in a position where the government has to regulate itself. And as you can see, there are examples where there aren't many lawyers that are going into Parliament as often. The legal background is not strong, and they're also not seeking it. We think an approach to AI to meet those challenges of how it will continue to expand needs to be adaptive and responsive and flexible in its approach from there. So that's where we're moving from, and that it should always have that ethical framework from its use.
And the next question, what are the key ways to enhance the usability of AI in legal practice, ensuring they're intuitive and effectively address the specific needs of legal professionals in New South Wales?
So we've been partnering with a number of the legal tech organisations that provide services to solicitors, and what we're finding when we're meeting with them and also discussing the needs of practitioners in New South Wales is that confidentiality is absolutely paramount. So whatever these ecosystems are that lawyers have is going to ensure that it maintains the confidentiality of the work that they have, but also of their clients, which again can be from government to private companies or private individuals, and with some very serious issues from there. What we're seeing is that AI at the moment is an assistance. So an example was used, think about an e-bike. So rather than pedaling up a hill yourself and exerting yourself and drudging through and grinding through, an e-bike, you're still doing some of the work, but a lot of the heavy lifting is done. So we're seeing that there's going to be enormous productivity gains with the use of AI, and partnering with AI rather than relying on it solely or ignoring it in its entirety is going to be the key to making sure that lawyers are on top of this, but also using it in the most ethical, transparent and productive way.
I'm glad you finished on that positive note. Would you please thank Brett McGrath?
Thank you.
Thank you.